Hi friends, I'm Chelsea Grayson coming to you once again from the Office of the CEO. This is my show where I can help you be more successful in your current career, and I can also help you successfully transition to a new career. So today we're continuing our multi-part series on breaking down legal agreements, how to understand the contracts that memorialize the deals that you've negotiated and want to enter into successfully. More importantly than just entering into them successfully, i.e. getting the ink on the dotted line, you want to make sure that these agreements are performed the way that you expected them to be performed when you negotiated the deal. And you want to make sure that they end the relationship the way it is supposed to be ended and at the time that the relationship is supposed to be ended. And equally as important, you want to make sure that to the extent that there's a dispute about the obligations of the parties or the way that they are performing their obligations, that there is a healthy method, a healthy blueprint laid out in respect of how those disputes will be handled, where they will be handled, who pays for the legal fees to the extent that there is a winner and a loser, etc. Right? So this is the second episode in that series. Today's going to be a quick one. I just quickly want to go over the importance of certain words and qualifiers that are typically used in legal agreements. So let's quickly get started. So the word shall, right? You shall do this. You shall not do that. That is a term that you specifically want to use to require performance or to prohibit certain behavior in your agreement. I very rarely use the word will. You will do this or you will not do that in place of the term shall. There's actually been some discussion in the legal and business community about the force of the word will compared to shall. Shall is generally considered to be a stronger requirement or a stronger prohibition on bad behavior in a legal agreement. So I generally use the word shall or shall not rather than will or will not. If you see an agreement that I've worked on that has the word will or will not, that's generally reserved for the predictive, right? You're predicting something that may or may not happen in the future. So it's more like you'll see that sort of language in the recitals, which are sort of generally predicting what we think the lay of the land is and why it is we're getting into this agreement, rather than in the body of the agreement where we're requiring people to do something or prohibiting them from doing something. So shall and shall not. The word may. This party may do this party may not do that. That's more about something that they may do, they are allowed to do. It's a permissive term. You would never, ever, ever substitute may or may not in place of shall or shall not. It's more about something that someone is allowed to do, right? They may enter into agreements with other parties that have to do with something other than the substance of this agreement. This party may compete in these certain respects, but they shall not compete in these other respects, right? So may is more permissive, what you're allowed to do rather than what you are required to do or required not to do. And finally, the term is. That is something that is generally reserved for statements with no actor, right? So a choice of law provision, for example, the governing law for any disputes between the parties to this agreement is the state law of California. The jurisdiction, to the extent that there's a dispute, is the county of Los Angeles in the state courts, right? Okay, so those are some quick word interpretations there. The other quick topic that I wanted to hit in this section are, let's skip ahead to a topic we discussed in the last episode, which are representations and warranties, right? So these are the statements of what is true right now, and that is incentivizing the other party to enter into this agreement or is giving them a risk shifting mechanism, right? So Corporation X is properly incorporated in the state of Delaware. So That says to the other party, I'm entering into agreement with a corporation that was properly formed in the state of Delaware. So now I've not only learned something about this other party because there's a statement in the contract that says it, so it's allowed me to do some diligence, right? Because they've said it here. So now I've learned something about this party and incentivizes me to get into an agreement with them because they're a properly formed organization. But it also shifts the risk over to that entity that's making that statement, right? Because to the extent that that representation about being properly organized in the state of California is not true, then it's the party that made that statement that can be sued for a breach of contract, and they bear the liability for any damages that happen by virtue of the fact that that statement was not true. So, for example, if Corporation Y is purchasing Corporation X, Corporation X has made a representation and warranty that we are, in fact, duly formed and organized in the state of California. That turns out not to have been true. Let's say there was a glitch and the paperwork was never properly filed, or they were late on their franchise tax fees, whatever the case might be. Whatever damages flow from that, penalties from the state of Delaware, contracts that that Corporation X thought they entered into as a duly formed corporation, but now are considered to be invalid because they were not properly organized. Any losses, liabilities, damages that flow from that, Corporation Y, the acquiring entity, can sue for breach of contract, i.e. a misrepresentation, and can get indemnified or get breach of contract damages for those to recoup for that loss, right? So that's what I mean when I say it's risk shifting. Now, if you are the party making that representation and you believe you can make this representation, but you want to hedge your bet a little bit, you can negotiate, or you can attempt to negotiate, you won't always be successful, with the other party, with Corporation Y, to say, let me put some sort of a qualifier on this representation to make it true, right? So you can say, we are in compliance of all environmental laws. That's a straight representation and warranty, right? Or you can say, we are materially in compliance with all environmental laws, right? Then now you need to figure out, so what is that materiality threshold? So that might mean that we're generally speaking, we're in compliance with all environmental laws, except to the extent that we're not in compliance with a particular law, but it won't result in damages above a very minimal amount of money, right? So in that case, if Corporation Y accepts that materiality qualifier, they're accepting the fact that however you define material in that agreement, and you certainly want to define it in some very specific way, that to the extent that this representation was not true, so there is some non-compliance with an environmental law, if it doesn't breach the threshold of materiality, so if the damages were only $100, maybe in some cases the deal is so big that $25,000 wouldn't even suffice to be material, Corporation Y is responsible for that. They can't sue for a breach of representation and warranty, and the risk shifts over to them. So that's what a materiality qualifier can do for you on the representer's side. It can help you say, well, look, we're not positive that we're fully in compliance with all of this. Maybe we're not positive that we were duly organized perfectly in the state of Delaware. We might have missed something here or there. So to the extent that there's something immaterial that doesn't rise to a certain monetary level, we don't get dinged for that. And there's all sorts of reasons that you would do it aside from the obvious reasons, right? You might be a company that just doesn't have the money or the time to go through and make sure that you can make a perfect representation and warranty, so you shift the risk over to the buyer. Sometimes buyers will accept that because they're getting something great in a different part of the agreement. Sometimes they won't because it's an incredibly important representation to them and they want to have solid responsibility on the sell side, right? So that just has to be up to negotiations between the two parties. A lot of times you'll also see ordinary course carve-outs. This is the one other carve-out that I wanted to point out to you, where you'll see except in the ordinary course of business, which is always a defined term in the agreement. So except in the ordinary course of business, for me as the selling entity, we aren't we aren't a party to any agreements that compete with the buyer's business. So let's just say your buyer is a SaaS company. You, as the target entity, are not a SaaS company, but you happen to have a few SaaS agreements in place, and that's just in order to run your business in the ordinary course. So you can say effectively, I'm not in any SaaS agreements, or I'm not in any agreements that compete with the buyer's business, except in the ordinary course. Sometimes you'll even be required to list out what those agreements are on a schedule. But the point is, you can't be sued later on for violation of that rep and warranty to the extent that a SaaS agreement was required for you to continue to run your business in the ordinary course. Now, again, in good agreements, the word material, to the extent it's used, and the word the phrase in the ordinary course, those are defined very explicitly in the defined terms section of the agreement, so that there's no argument later on about what it takes to rise to the level of materiality and what is in the ordinary course of business for the target. So those are just some quick defined terms that I wanted to go over for you guys. These are typical words that you're going to see in a legal agreement or contract. You need to focus on those. You need to go back to your defined terms and understand exactly what those mean. But again, to the extent that you're the target or the seller in a particular agreement, or to the extent that you are the under-leveraged party and you're required to obligate yourself to certain things, or you're required to make certain reps and warranties, some of these phrases can really help you out and can really effectively shift some of the risk, some of the burden over to the other party in the agreement. So that's the episode for today. Be sure and subscribe to my YouTube channel so you don't miss future episodes. And I will continue to go over some really important common terms in legal agreements in the next episode that I'll either put up later on this week or next week. So I will see you guys next time from the Office of the CEO.